Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome to Legalese 123. I'm your host, Missy K. Happy New Year! I hope everyone had a wonderful and fun celebration these past couple of days, and hope you have some beautiful and wonderful things that you are planning for this year of 2026. I believe it is the year of the horse. So, as you might have seen, I have thrown out some TikToks and I've thrown out some YouTube shorts, etc. Make sure that you like and follow because we're going to have a lot more content coming up this year. And wow, you think that these days are slow days? Nope. Hold my beer, hold my champagne, I'm actually drinking some electrolytes. Hold my electrolytes. So, you just never know. So what's going on? Well, as I mentioned earlier, Aiden Kearney's case is coming up. The 23rd of January is going to be here before you blink. It's already the 2nd, right? So in 21 days, it's going to be super exciting. Is Cosgrove going to be disqualified from his case? Well, Olivia, the wonderful paralegal for Tim Bradel, has just chucked out one of the filings and we have it. So everybody else is going to go through it, but I thought I would try to do it first. So here we go. We're going to add it to the stage. You're going to make me smaller. Again, this is the Sir reply motion to disqualify Robert Cosgrove. So let's do a little backtrack. Who is Aidan Kearney? Aidan Kearney, aka Turtle Boy, Dr. Turtle Boy, Crowd Daddy. He's a whole bunch of daddies. Long story short, Aidan Kearney was instrumental in the Karen Read case. When I say instrumental, he was the boots on the ground trying to get as much information to the people about her case and how her case was very suspicious as to what had transpired with John O'Keefe's death. Did Karen Read hit him with a car? Did the House defendants do something nefarious and put him out on the lawn? We may never know the answer to that question, but what we can talk about and describe is the actions that Turtle Boy has put forth in order for Karen to get the attention that she needed for her case. He was the boots on the grounds. He was the one on his YouTube channel screaming from, the rooftops, stating that Karen was innocent and that there was a lot more going on behind the scenes as far as corruption with the police, biased against her, etc. If you don't know about the Karen Read case, go look at the show notes, go look at YouTube. It's a big deal. So Aidan Kearney is an investigative journalist who has helped Karen Read in her cause. He is being charged with witness intimidation. The House defendants have said, "You intimidated me." What does that mean? Well, we don't have the full details, but we have some small details. So there is a special prosecutor in his case. This is the second special prosecutor. The first one was Ken Mello, and now the second one is Robert Cosgrove. Ken Mello got sick. Cosgrove's up next. Aidan Kearney had a prior case with which Cosgrove was the special prosecutor on. It also involved a ex-paramour of Aidan Kearney's named Lindsay Gattani. That case has been dismissed because Special Cosgrove was being sued by Lindsay because Brian Tully, MSP Trooper Brian Tully, had downloaded her phone and had given it out to everybody. So they violated her rights in her words. So Cosgrove was kicked off of that case because she sued him as well as Brian Tully. And now Aidan Kearney's two attorneys, Mark Betterow and Tim Bradel, are stating that Cosgrove needs to be kicked off of this case because Lindsay Gattani is a witness in this case. There is a motion to disqualify Robert Cosgrove on the 23rd of January. So Aidan Kearney has been ebbs and flows with his case. And every time they feel like they're making headway, they get a new judge, the prosecutor, everything just sort of comes to a halt. And now we're making momentum footsteps forward in order to get this case on the right track. Got a new judge, special prosecutor still in play. And now where are we? We're in the area of, is he going to be disqualified? So let's read this latest Sir reply motion to disqualify him. All right, so I have made it big. I hope that is big enough for you guys to read along. So let's play. I wish I had like a da-na-da-na-na-na. All right. Public confidence in the integrity of the criminal justice system is essential to its ability to function. Oh, isn't that nice? You can tell Betterow wrote this. The Commonwealth's response envisions Robert Cosgrove's conflict with Lindsay Cattani in a vacuum. It ignores that separate and apart from Mr. Cosgrove's conflict, the case against Aidan Kearney is rife with other conflicts and scandals, the combined impact of which severely undermines the public's confidence in the integrity of the Norfolk criminal justice system. A summary of these conflicts and scandals follows. In September of 2023, Norfolk District Attorney DA Michael Morrissey recused his office from prosecuting Mr. Carney due to the conflict created by investigating a journalist who publicly accused the DA's office, the Massachusetts State Police, and various civilians of framing Karenread for M. After the Attorney General rejected his entreaty to prosecute Mr. Carney, DA Morrissey engaged Kenneth Mello and Robert Novak as special prosecutors. The MSP Norfolk State Police Unit, SPDU, did not recuse itself, even though it labored under the same conflict as the DA, given Mr. Carney's accusations that Detective Lieutenant Brian Tully, former Trooper Michael Proctor, and Sergeant Yuri Buchanan were corrupt in the Reed case. Interesting. Mr. Betterow has made an affidavit. We'll go over that later. The full breadth of the Norfolk's, what are we going to call it? SPDU's investigation based bias, I'm still the SPDU's, investigates bias against Mr. Carney has been bolstered by the Commonwealth's latest disclosure and recent social media post made by Sergeant Buchanan on January 28, 2025, in response to Mr. Proctor again smearing Mr. Carney as a blank, redacted because we don't know what he called him. Sergeant Buchanan assured him that Mr. Carney, who he disparaged, blank, would blank, blank, blank. Probably like put him in jail. Sergeant Buchanan giddily told Mr. Proctor that the blank awaiting Mr. Carney and other unnamed people would be blankety blank, blank, blank. I don't know. I'm just guessing because it's redacted. Exhibit A. Ooh, let's go see what Exhibit A is. Probably redacted. Redacted. Boo! Boo! It's okay. Mr. Proctor, I'm sure Aiden will probably go over this and probably give you some hints. Mr. Proctor hoped his colleague was correct. Sergeant Buchanan shattered any facade of impartiality in his investigations of Mr. Kearney and Miss Reed by professing enthusiastic support for Jennifer and Matthew McCabe and the Alberts, and by revealing his overt bias against and disdain for Mr. Kearney and Miss Reed. Leveraging his status, Exhibit B. Oh. Yuri Buchanan had then as I post infrequently when I do, it's usually noteworthy. The struggle of the conflict is straightforward. It's a contest between decency, justice, and order versus evil. So okay. Leveraging his status as a supervising detective in the case against Mr. Reed and Miss Carney, Sergeant Buchanan actively solicited money for witnesses against Mr. Carney and Miss Reed. Oh boy. I had wondered if this was going to come up. Oh, boy. At least 7 times from November 25th to December 2nd, even referencing Thanksgiving, Black Friday, and Giving Tuesday as perfect days for happy donating everyone. In one post, Sergeant Butnick included a fundraising link and issued a call to arms seeking financial support for the good, the McCabe's and Alberts, in their fight against evil, Mr. Carney and Miss Reed. Oh boy. Footnote 1. In addition to participating in the investigations of Mr. Carney and Miss Reed, Sergeant Butnick testified that he was intimidated by Mr. Carney lobbying questions at him as he left court one day. An indictment related to this incident was dismissed. At Miss Reed's 2025 trial, Sergeant Butnick was detailed the MSP investigation. Sergeant Butnick repeatedly directed potential donors to a website created to support the McCabe's and Alberts, whose mission statement is to protect and empower witnesses and victims of crime who face retaliation, harassment, or defamation for fulfilling their civic duty. Emphasis added. In another post, Sergeant Butnick disparaged Mr. Carney and Miss Reed's supporters for their low level of intelligence, for believing conspiracy theories, and for proudly helping ruin innocent people's lives. On November 29th, 2025, Sergeant Butnick put to rest any notion of the Norfolk Spadu's actual bias against Mr. Carney and Miss Reed by posting a donation link and revealing himself as the spokesperson for the McCabe and Albert fundraising operation, writing, "Every donation doesn't matter the amount, makes a huge difference. Your generosity matters, and the ones in need greatly appreciate your support. I personally thank you on their behalf." Oh boy. Sergeant Butnick's crowdsourcing of funds for prosecution witnesses against Mr. Carney and Miss Reed may violate Massachusetts' conflict of interest. Either way, his overt advocacy for these witnesses and his clear bias against Mr. Carney and Miss Reed makes a mockery of any appearance of the impartiality in the Norfolk Spuds investigations of Mr. Carney and Miss Reed, and obliterates whatever confidence the public had in the integrity of these investigations. Mr. Mello was disqualified from the 2024 indictment after he made himself a material defense witness. He withdrew from the instant matter while a motion to disqualify him was pending, which included, among other things, proof that he advocated on behalf of witness Chris Albert while exploiting his official capacity as Mr. Carney's prosecutor. Mr. Novak sought to formally withdraw one day after defense motions to dismiss, alleging pervasive prosecutorial misconduct were filed. In March of 2024, DA Morrissey engaged Mr. Cosgrove to assist Mr. Mello with legal analysis and motion work on the pending cases against Mr. Carney. In September of 2025, Mr. Cosgrove voluntarily withdrew from the 2024 indictment, citing an ethical conflict with Ms. Gattani after she sued him and D.L. Tully for intentionally violating her rights during their investigation of Mr. Carney. In June 2025, Ms. Reed was acquitted of all charges related to the death of John O'Keefe. A few months later, Ms. Reed sued several witnesses against Mr. Carney, among others, for conspiring to violate her civil rights, including D.L. Tully, Sergeant Butnick, Mr. Proctor, Miss McCabe, Mr. McCabe, Brian Albert, and some of these witnesses' defendants have threatened to sue Miss Reed and Miss Carney, but have not done so. If the court permits Mr. Cosgrove to remain in this case, he will be prosecuting a high-profile matter of public concern, alleging that Mr. Carney intimidated witnesses while he reported on a case against a woman who was acquitted after 2 high-profile trials under the following circumstances. Mr. Cosgrove has been sued for intentional misconduct by Ms. Gattani, who previously testified for the prosecution, but is now a likely defense witness. D.L. Tully has been sued by Ms. Gattani for intentional misconduct and Mr. Cosgrove's co-defendant. D.L. Tully has been sued by Ms. Reed for violating her civil rights. D.L. Tully has been disciplined for his misconduct in the Reed case. Ooh. Detective Lieutenant Brian Tully, Division of Investigative Services, and Detective Lieutenant about February 1st, when he did fail to conform to work standards established by his rank, title, position. This occurred when Detective Lieutenant failed to supervise. Oh, that is when he failed to. That was reference to the Proctor text. Proctor had a group text of his lieutenants and stuff in his Norfolk District Attorney's people, and I think Tully thumbs-upped it, something like that. Sergeant Buchnick has been sued by Miss Reed for violating her civil rights. Footnote 3. Miss Reed is a defendant in a pending lawsuit filed by the estate of John O'Keefe. Footnote 4. Matthew McCabe, Brian Albert, Chris Albert, Colin Albert, Juliana Nagel, and Mr. Proctor did not testify at Miss Reed's 2025 trial. Elizabeth Proctor did not testify at either of Miss Reed's trials. Sergeant Buchnick was disciplined for his failure to supervise Mr. Proctor in the Reed case. Sergeant Buchnick's documented actual bias in favor of the McCabe's and Alberts and against Mr. Carney and Miss Reed will be exposed to the jury. Probably redacted. Dang it! Mr. Proctor has been sued by Miss Reed for violating her civil rights. Mr. Proctor authorized text disparaging Mr. Carney and revealing his investigation. I bet you this is redacted. Oh. Let's continue. Okay, let's continue to do nothing because that has worked out so well at this point. A-hole was in a recent YouTube clip saying he's going to take my kid after I'm arrested and my wife is getting emails at work because he's telling everyone she's fired. Sitting back and doing nothing hasn't helped. So what's the difference if we arrest him? Clearly, doing nothing isn't working. And my family, the McCabe's and Alberts, are done. Oh, lovely, Mr. Proctor. Okay. And revealing his investigative bias during the MSP investigation. Mr. Proctor's repulsive text messages about Miss contributed to his termination from the MSP. Mr. Proctor's electronic communications have jeopardized numerous other cases and made him a national poster child for police misconduct. Oh my gosh. Oh my gosh. Poster child from police misconduct. You just can't make this stuff up. 3 key civilian witnesses against Mr. Carney, the McCabe's and Brian Albert, have been sued by Miss Reed for conspiracy to violate her civil rights. And Miss Catani's testimony will undermine the credibility of D.L. Tully and Miss McCabe, which will subject her to cross-examination by Mr. Cosgrove, and then likely result in Mr. Cosgrove. Oh, well, that was a typo. And then likely result in Mr. Cosgrove attacking the credibility of his civil accuser. This is the landscaper facing the court as it considers whether the public's confidence and integrity in this matter and the Norfolk County criminal justice system will be further eroded by allowing Mr. Cosgrove to prosecute Mr. Carney, notwithstanding Ms. Catani's formal accusations against him. Argument. Put it simply, as related to Mr. Carney, footnote 5, Mr. Cosgrove is prosecuting Mr. Carney in a 2025 witness intimidation indictment in which Chris Albert and Colin Albert allege that they were emotionally harmed by reviewing video of Mr. Carney clowning around as he looked into the video camera outside of Chris Albert's pizza shop. On December 5th, 2025, Mr. Cosgrove stated his preference to withdraw from the 2025 matter if the court disqualified him from the 2023 case. Ms. Kearney is unlikely to be a witness in the 2025 case, thus the defense has not sought to disqualify Mr. Cosgrove from that matter. This begs the question, why is Mr. Cosgrove interested in remaining on the 2023 case, but willing to abandon the 2025 case? I thought the same thing. Great question, Mr. Betterow. We're on the same page. Mr. Cosgrove is the Commonwealth. As a consequence of the above described conflicts and scandals plaguing the prosecution of Mr. Kearney, the Commonwealth's last remaining prosecutor is one who already recuses himself from another case due to his conflict with Miss Kearney. The undesirable reality that Mr. Cosgrove's disqualification will leave this case stateless is the Commonwealth's problem. It may arise from some difficult questions about the prosecution of Mr. Kearney, but it should not factor into Mr. Cosgrove's fitness to remain on the case. Okay, before we move on, we are on page 9 out of 22. Let's see if we can see this video. Let's see if we can play it. Okay. It doesn't have any sound. It doesn't have any sound that I can hear. Oh, here it's got sound now. Oh, that's Will, the glare, right? I'm not sure. I forget who that is with him. This is his witness intimidation, window intimidation. Okay, it's really funny, but we're going to continue on. Wow, that's really funny. Now, I don't know what else he said, so we'll have to wait and see. All right, we'll come back to it. A further consequence of Mr. Cosgrove being the only prosecutor on this case is that the Commonwealth's response was drafted by a conflicted prosecutor, rather than one without a personal interest in seeing Miss Kearney's discredited. Not surprisingly, the tone and substance of Mr. Cosgrove's response illustrates the conflict between him and Miss Kearney. Before Miss Kearney accused him of intentional misconduct, Mr. Cosgrove successfully fought to prevent the public release of embarrassing and private details from her personal life by seeking broad impoundment and protective orders. His view apparently changed once Miss Kearney sued him. In his response, Mr. Cosgrove publicly regurgitated what he previously condemned Mr. Kearney for widely disseminating about Miss Kearney. We're not going to see the opposition memo. Even worse, in his response, the prosecutor being sued by Miss Kearney muses aloud about whether she might be prosecuted for perjury if she testifies as a defense witness at trial. Mr. Cosgrove's implication that Miss Kearney's anticipated U-turn testimony may expose herself to legal peril. That's right. So Mr. Cosgrove's response to Aiden Carney's stuff and Lizzie Kearney, etc., he stated that Lindsay making herself a witness might bring legal peril on herself. Serves as a public warning to Miss Kearney that she should not testify at Mr. Carney's trial. Left unanswered and emblematic of the conflict that compels disqualification, and whether Mr. Cosgrove is expressing his personal opinion about Miss Kearney's credibility and criminal exposure in the event her testimony favors Mr. Kearney, or whether he speaks for the public as a representative of the Commonwealth. Of course, this wouldn't be an open question if the Commonwealth had the wherewithal to have its response to a disqualification motion drafted by someone other than the prosecutor who is the subject of this application and whose response includes his personal opinion that the witness suing him likely will perjure herself if she testifies at trial. Either way, the conflict is undeniable. Mr. Cosgrove personally benefits in the civil case by discrediting Miss Kearney in the criminal case. Footnote 6. In an ordinary situation, a prosecutor might express concern about a witness's possible criminal exposure, but the dynamics between Miss Kearney and Mr. Cosgrove is far from ordinary. Mr. Cosgrove has no such concern for Miss Kearney's welfare when he called her as a prosecution witness against Mr. Kearney at a district court trial after the defense brought information to the Commonwealth's attention that Miss Gattani would expose herself to possible perjury charges if she testified as anticipated. Now that Miss Gattani's interests are adverse to his own, Mr. Cosgrove has publicly expressed concern that she might perjure herself if she testifies in a manner favorable to Mr. Carney. His continued participation in this matter will lessen the public's confidence in the integrity of the prosecution. Nor should the irony of Mr. Cosgrove's comments about Miss Gattani's credibility be lost on the court. A civil defendant prosecutor with a clear personal motive to discredit his accuser and or prevent her from testifying issued her a public perjury warning in a case in where he will argue to the jury that Mr. Carney attempted to intimidate witnesses by, among other things, urging them to tell the truth. This case against Mr. Carney is a high-profile public matter concern which raises serious issues regarding the intersection of protected speech and alleged witness intimidation. Mr. Carney and the public are entitled to a conflict-free, unbiased proceeding in which he and the public have confidence. This case cannot credibly proceed in its current posture. Mr. Cosgrove's personal interests in discrediting Miss Gattani conflicts with Mr. Carney's, the Commonwealth, and the public interest in fair and just legal proceedings, and compels his, footnote 7, the Commonwealth's broad interpretation of the intent and emotional injury elements of witness intimidation. Who knows if Miss Gattani, a witness against Mr. Cosgrove, will allege that public statements by a powerful prosecutor defendant warning her about criminal exposure if she testifies constitutes witness intimidation of her by the adverse party in her lawsuit. Okay, so we're here. It compels his disqualification for the exact reason Mr. Cosgrove voluntarily withdrew from the 2024 indictments. *****. It is fundamentally unfair to permit a district attorney to prosecute a case where he has a personal interest which prevents the district attorney from serving his only permissible master, the public. Didn't stop him in the Karen Read case. It is, of course, improper for a prosecutor to participate in a case where he has a, big word, interest. Pecuniary? If the prosecutor's personal interest as the defendant in a civil case will be furthered by a successful criminal prosecution. In such circumstances, a conflict arises between the prosecutor, as a representative of the public, must seek justice to protect the innocent as well as convict the guilty. And prosecution by a civil defendant may deny the impartial exercise of a prosecutor's discretion. Notwithstanding his personal interest in discrediting Miss Gattani due to her allegations of misconduct against him, Mr. Cosgrove reasons that the same conflict that led him to voluntarily withdraw from the 2024 indictment does not require his disqualifications here because A, Miss Gattani is not necessary, she's not a necessary Commonwealth witness, and B, any testimony she might provide is not relevant. He is wrong. A defendant has a constitutional right to attack witnesses' credibility by establishing that witnesses' bias and motive to falsely accuse him. This includes revealing possible biases, prejudice, and ulterior motives of the witnesses as they relate directly to the issues or personalities in the case at hand. Davis v. Alaska. Assuming arguendo that Mr. Cosgrove does not call Miss Gattani as a witness and that her testimony would not be relevant to the substance of the indicted charges, Miss Gattani's testimony will undermine the credibility of key prosecution witnesses D.L. Tully, Miss McCabe, and possibly others. See the federal affidavit. In addition to be examined about issues that adversely impact Miss McCabe's credibility and D.L. Tully's possible tampering with her cell phone, Miss Gattani may be questioned about separate civil allegations. pending against D.L. Tully in 2 lawsuits. In any scenario in which Mr. Cosgrove examines these witnesses and/or comments on their credibility, fundamental fairness requires that the jury be made aware that the prosecutor addressing it has a personal interest in discrediting Ms. Kearney and crediting those whose credibility is damaged by Ms. Kearney. But such a scenario would expose the jury to Mr. Cosgrove's conflict of interest, which means that the proper remedy is to ensure that another disinterested prosecutor conduct these examinations and address the credibility of these witnesses. Disinterested, I like that word. It is axiomatic that an individual prosecutor cannot prosecute a case in which his personal interests differ from those of the Commonwealth. Where there are significant risks that an individual prosecutor representation of the Commonwealth in a specific matter will be materially limited by the lawyer's personal interests, the prosecutor shall not represent the Commonwealth in the case. See Massachusetts Rules of Professional Conduct. Footnote 8. The court has discretion to decide whether D.L. Tully is credible is a crucial issue and whether his alleged misconduct is admissible in the interest of justice. Oh, matter of grand jury investigation. Oh, that is just... All right. I thought there was going to be something cool. No. Case law, case law. Here, Mr. Cosgrove's personal interest in seeing Ms. Kearney discredited differs from the Commonwealth's interest, which in every case is to see that justice is done. The district attorney properly has only the master of the people of the Commonwealth. His duty is to seek justice and protect the innocent as well as to convict the guilty. In accordance with its obligation to see that justice is done, it is the Commonwealth's interest to investigate allegations that may adversely impact the credibility of its witnesses, even if the result may favor Mr. Kearney. Well, they didn't do that in Karen Read's case, now did they? It is therefore incumbent that the Commonwealth fully vet Ms. Kearney's claims regarding the credibility of D.L. Tully, Ms. McCabe, and others. Ms. Kearney has alleged that she was pressured to cooperate by Ms. McCabe. She claimed that Ms. McCabe provided benefits to Catherine Peter. She asserted that Ms. McCabe has voodoo dolls of Mr. Kearney and Miss Read in her home. She was told by Catherine Peter that Miss McCabe was worried about the disclosure of text messages between her and Carrie Roberts, which revealed that a few days after John O'Keefe's death, they discussed who would play them in a movie. It is in the Commonwealth's interest to investigate these claims because if they are true, Miss McCabe's credibility will be undermined. Ms. Kearney will testify that D.L. Tully intentionally mishandled her cell phone by tampering with and/or deleting its contents. D.L. Tully will deny this. Mr. Cosgrove has accepted D.L. Tully's explanation without any further investigation. Clearly, these issues are relevant to D.L. Tully's credibility, and the jury should not be ignorant to the fact that the prosecutor addressing it has a personal interest in favoring D.L. Tully over Ms. Kearney because he was sued by Ms. Kearney and is D.L. Tully's co-defendant. Footnote number 9. On November 20th, 2025, Ms. Roberts publicly claimed that she and Ms. McCabe joked about Sandra Bullock coming out of retirement because they needed her. Ms. Roberts also said that they determined Ms. McCabe was Angelina, presumably Angelina Jolie, and that we even had an actor in mind to play Mr. O'Keefe in the movie. As in the case with evidence regarding Ms. McCabe's credibility, it is the Commonwealth's interest to determine whether Ms. Kearney's allegations about D.L. Tully are true. But it is in Mr. Cosgrove's personal interest to simply credit Ms. McCabe and co-defendant D.L. Tully and to discredit Ms. Kearney. Moreover, Mr. Cosgrove is incapable of acting in the Commonwealth's interest regarding Ms. Kearney's allegations, because he cannot directly engage his accuser. In any event, it is hard to fathom why Ms. Kearney would agree to speak to Mr. Cosgrove about these issues given her present legal entanglement. She can't talk. She's suing him. The bottom line is that any scenario in which Mr. Cosgrove argues in support of D.L. Tully's credibility and or against Ms. Gitani's credibility serves his personal interest above all else. There is simply no way around this conflict. As described by the D.C. Circuit Court of Appeals, Ms. Gitani's unvetted allegations make it untenable for Mr. Cosgrove to prosecute this case because his personal interests in discrediting Ms. Gitani is in conflict with the Commonwealth's interest in seeking that justice is done. Like, I feel like, justice is done. And leads to the inescapable conclusion that his participation fails to preserve the appearance of impartiality in the proceedings. As previously noted, this appearance of impartiality will further destroy the Norfolk Spidoo's failure to rescue itself. Mr. Proctor's bias and disparaging comments about Mr. Carney during the investigation and evidence of Sergeant Buchnick's lack of impartiality, fundraising efforts, and advocacy on behalf of witnesses against Mr. Carney. In these circumstances, it is improper for the prosecutor to participate in a case where a threat to his personal and professional reputation is created by a bona fide civil lawsuit alleging bad faith in the performance. This is the exact situation that exists here in the light of Ms. Gitani's allegations against Mr. Cosgrove. Footnote number 10, which is very large. Sergeant Buchnick's fundraising on behalf of prosecution witnesses obligates the Commonwealth under Brady Giglio Rule 14 to investigate and then disclose any evidence that tends to show that the McCabe's Alberts were offered, sought, expected, or received any possible benefits related to Sergeant Buchnick's solicitation on their behalf. This includes communications between and among Sergeant Buchnick and the witnesses and records of money received by the witnesses related to Sergeant Buchnick's request for donations. Mr. Cosgrove's opinion that Ms. Gitani's lawsuit will not survive a motion to dismiss doesn't absolve the conflict. The conflict is created by Ms. Gitani's allegations, which, even if not the subject of an active lawsuit, create the risk of reputational and professional damage to Mr. Cosgrove. Boy, here we go. We are on page 20. Accordingly, given the need to promote the appearance of justice, a trial court on a timely motion to disqualify a prosecutor from participating in criminal action when he has a personal conflicting interest in a civil case. The district attorney must be held to the highest ethical standards, which include the appearance of a conflict of interest. Disqualification appropriate where prosecutor has a significant personal interest in a civil matter which may impair his obligation in a criminal case. Conclusion. The foregoing reasons and those stated in the prior defense submissions, the court should disqualify Mr. Cosgrove from the prosecution in the docket 2328 CR 00313. Signed, Mr. Bedrow and Mr. Bradle. Do-do-do-do. Oh, boy. Wow. If you did not see the hearing that Judge Belazos had with Aiden Kearney's team and Mr. Cosgrove, you definitely should go watch that. I think I covered that. The new judge was like, hey, listen, you guys have to have your motions and everything in by like the first week of January. So I think that's next week. So Mr. Cosgrove has some time to respond, etc. And he was like, do not belabor this point. Just get to the point. Give me like a brief synopsis of what's going on. But I do find it quite interesting that Judge Belazos, who is a new judge who actually took over for Cosgrove, believe it or not, in the Norfolk area. He's not currently sitting in Norfolk. Judge Belazos is not currently sitting in Norfolk. He's sitting in Suffolk County right now. And that is where Aiden's hearing is going to be held, not in Norfolk. It's going to be in Suffolk. Sad, but we'll see if it can be covered. Long story short, new Judge Belazos, welcome. Welcome to the Massachusetts, right? Norfolk, Massachusetts, right? You can't make this stuff up. So this is the latest and greatest from the Aiden Carney case. I just posted a video earlier about what's going to happen next. Recap. On the 23rd of January, there will be a hearing, and Carney's attorneys and Cosgrove will get up and explain why they think Mr. Cosgrove should be disqualified and why Mr. Cosgrove thinks that he should not be disqualified. And then we sit and wait with bated breath to find out what Judge Belezos is going to say. But I would like to be a fly on the wall to see Judge Belezos' face when he hears all about this case. He said in his last hearing that he had read up on some of it, but it just continues to be conflated and conflated. You just can't make this stuff up, right? And now the added layer, there's like this cake, and it just keeps growing with so many layers. And now on top layer is this Sergeant Buchnick has went ahead and made statements to donate to the defense of the House defendants. So with that, please make sure to like and comment. Tell me how you think this case is going to end up, what your thoughts and feelings are. So that's all we have for this night. We'll see you again on the next one. Make sure to like and subscribe for more content. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.